Thank you very much. It's such a pleasure to be here this afternoon now, because I'm really excited to be here to just share with all of us some of the outcomes of research that we have been conducting on the right to privacy and data protection. Let me also thank ISGPP, PIN, Web Foundation, and Google for this opportunity, and also the opportunity to be part of the work of the African Academic Network. So let me also say that I'm a lawyer. And I'm a human rights lawyer. So it's something I've been doing for a couple of years right now, and inevitably, everything I see is through that lens. So please forgive me if this presentation is, if in your opinion, is focused too much on the human rights aspect of data protection. But I guess there are also parts of it incorporated with ICT and all that. So just to give you a brief overview of my presentation, and to say that this is actually just trying to tease out the key findings of quite voluminous research in this field. So what I'll be doing is giving a very brief introduction on what are human rights, and also trying to identify the 3 key rights that are of relevance in this conversation, which are freedom of expression, access to information, and the right to privacy. And then I'll then be looking into the legal framework on 2 of these rights I have mentioned, which is access to information and privacy, and then seeing how this relates to how they are interconnected. And then we'll then go through the broad landscape on what privacy, what the legal framework on privacy is on the continent. We'll look at things like what exactly is privacy, what is overview of the international, regional, and then also national legal frameworks on the right to privacy and data protection in Africa. And then I'll identify some of the gaps that have been noticed in the legal frameworks that have been discussed, and then, of course, proceed to discuss recommendations at the international, regional, and national level. Okay, so I had this fantastic idea of showing a few videos, but now that we're severely behind time, and I've also been told that some videos were showed earlier, I think we'll skip that. And then I'll go to what are human rights. So, I mean, generally we'll say human rights are rights we have by the virtue of being human. And a very good way of capturing that is what we have in the Universal Declaration of Human Rights that talks about all human beings are born free, equal in dignity and in rights. And I'd like to identify some of the 4 main characteristics of human rights, which I think are very important to the conversation we're having today, which is that they're universal. So this means that although we have generally 3 so-called categories of human rights, the civil and political rights, social economic rights, and the group rights, they are still all very important and equally important. There's no hierarchy of rights, so they're indivisible. And also that the fact that they're interdependent, which means that the enjoyment of one particular right is important for the enjoyment of all other rights. So in essence, it's about how do you then balance at any given time one right against the other. And obviously, they're all interrelated. So for example, I have mentioned freedom of expression, access to information, and privacy are all related one way or the other. And then just to highlight that, for human rights considerations, the ultimate burden lies with the state. So the state is the primary duty bearer for human rights. So human rights are addressed basically to the state. And in this context, they have 3 main obligations, which is to respect, to protect, and to fulfill. So in terms of respecting, that obviously is like a negative imposition. They're meant to ensure that they do not do anything to interfere with rights of people living within the state. To protect is more of like a big brother kind of approach, to make sure that third parties do not interfere with rights, of people living within the territory. And to fulfill is now the more positive, practical aspect of taking time and adopting laws and policies to actually then give effect to the commitments at the international and regional level by signing treaties, adapting, the legal framework within the country. I'll skip just to say that at the end of the day, the ultimate aim of international treaties that our countries sign is to, obviously, these treaties are written in a very declaratory manner. So if you look, for example, at the Universal Declaration that says all human beings are born free, equal in dignity and in rights, that's Article 1. That doesn't say anything about rights. It's just a general declaratory statement. Is then how do you then take that declaration and then gradually, through laws and policies, make it a reality within your domestic legal framework? So these are some of the issues I want us to just have at the back of our minds, as I go along with the presentation. Okay, so here we have a diagram just to show the interconnectedness of these three rights: freedom of expression, access to information, and privacy, or I call it protection of personal information, which I should say now it's a bit strategic because of the fact that, as you will see later on, the right to privacy is not recognized within the African Charter, but there's a sort of recognition of protection of personal information. So that's why it's referred to as that. So, we can readily think about what is the connection between these three rights. Freedom of expression is about us, sharing our opinions, without any hindrance by the state or by other third parties. But at the same time, if you don't have privacy to share your opinion, if you feel that the government is going to snoop on your communication and it's going to reprimand you for what you've shared, then you can't really express, your opinion, as well as the right of access to information. So access to information on its part is about how do we ensure that information that is held by the government is made readily available to the citizens proactively, without the need to ask. And even when they ask, how do you then ensure that the information is provided, to people that need it? Because without access to information, for example, about the policies of government, how then do you take the government to task and say, for example, there has been corruption in this sphere? It's about the information you can get from the government that allows you to then be able to freely express your opinion, and also then the right to privacy. So these three rights are very interconnected. But for today, we're going to be focusing on access to information and the right to privacy because they are the most interlinked. So just to highlight that the fact that access to information, which I call ATI, and privacy are extremely intertwined. And that's part of the reason why you will find that in some countries, very few though, you have, for example, in Canada, in UK, no, not Canada, in UK, Mexico, and South Africa, you have one body which is overseeing the implementation of both rights. So the whole idea is to be able to see that both rights are balanced in a proper manner. And also the fact that, so access to information, really, the essence of it is about accessing information held by government or public bodies, but now it's increasingly being applied also to private bodies, subject to clearly defined exemptions. So the whole idea here is to show that the right of access to information is one that takes into account privacy. If you look, for example, at the General Comment 34, which is based on the International Covenant on Civil and Political Rights, an interpretation of it, it talks about the right of individuals to access personal data stored in automatic files, and also being able to stipulate which public authority or private individual or body may control those files. And then most importantly, the right of an individual to be able to have the records or rectified or deleted where the information has been processed contrary to the provisions of the law. Just to move to the regional framework within Africa, that is. So we have the African Charter on Human and People's Rights, which is a continental body treaty for regulating human rights on the continent. As far as I know, all states have ratified the Charter, including Nigeria, but I think Morocco hasn't, so that's the lone ranger in that regard. And within the African Charter on Human and People's Rights, like I said, there is no right to privacy, right? But the right to the protection of personal information is recognized as an exemption to the right of access to information. So it's almost like when you talk about access to information and privacy, they seem at first glance as they're two opposing rights completely. Because one is saying, I want information, give it to me. The other is saying, no, I'm not going to give you my information, but I'll give it to you, or I'll give it to you on my own terms, right? But both are rights, and both should ideally be respected. But the issue here is that access to information recognizes that you can't always give everybody all the information that they need. So, in certain circumstances, you can't say, I'm not going to give you my personal information because it's my personal information. So clearly, the African human rights system has recognized the right to privacy indirectly because, for example, the Declaration of Principles that was adopted by the African Commission recognizes that, but not the right to privacy. And then now looking at constitutions that talk about access to information. So obviously, access to information is a relatively new right, generally speaking. But we have about 13 constitutions in Africa that protect this right. And 6 of these constitutions speak directly to the issue of personal data protection in the context of the right to privacy. So we have, for example, in Kenya, what Kenya talks about is that you have the right to correct or delete untrue or misleading personal information. That is within the provision of access to information. And then you also have Seychelles that talks about the right to rectify or otherwise amend inaccurate personal information. And then we have the other 4 who, what they talk about is what I've just said now, that the right to privacy is a limitation to the right of access to information. So clearly we can see that within the sphere of human rights, it is recognized that access to information is generally the rule, but the right to privacy has to be balanced with access to information as well in certain circumstances. So it's like a limitation on the right of access to information. Just to run through this, so we have 20 laws on the continent that talk about access to information. Each of these laws as well recognize the right to privacy as an exception to the general rule. So they will the laws will say that the general rule is access to information is provided, but we will not allow you to have, there will not be unreasonable disclosure of the personal information of a third party. So those are the countries that have all those laws. But then they've also identified the circumstances in which you will not consider disclosure of the information to be unreasonable. So just for a few examples, as in line with the general data protection principles. So for example, if you expressly give consent, then obviously the issue of the disclosure being unreasonable no longer arises. Or if you are told, this information has been requested, can we give it to ABC? And you do not respond, or you do not actually object to it, then obviously it's not unreasonable disclosure of information. An interesting one also is when you are an employee of a public body, and the information is about your function in that role. This is, for example, to cater for issues of corruption or mismanagement of resources. You cannot now say, I have a right to privacy because you want to cover up such kinds of misdemeanors. And there are several other instances which I will not go into. But so, for example, there's also, if the information is already in the public domain, then you cannot really say you are breaching the right to privacy. Also, so these are some of the provisions in some of these laws that I'm mentioning. And obviously, when the disclosure is mandated by a court order, I mean, you have to comply with the court order. You cannot then say that you're trying to protect, or you're trying to give effect to access to information. And then I move to the real conversation of today. What is privacy? And with many concepts in the human rights field, it's quite elusive. So you think about privacy and then immediately you think it's about being secretive, not sharing information, but it's actually a bit more complex than that, or a bit more broader than that. Let me just read from here that the lack of a definition of the right to privacy has been compounded, according to the Special Rapporteur of the UN, by what he has termed the time, place, economic, and technology dimensions of the right to privacy. What this really means is that the specific factors such as time, context, economic development, and technological advancements combine to determine what can be regarded as the definition of the right to privacy with any given legal system. It is fluid. It will depend on a variety of factors. Despite that, one can say that privacy relates to the autonomy of the individual and the freedom from interference with the full development of his or her person. It can be described as the ability of an individual to freely decide under what circumstances and to what extent they will expose themselves, their attitude, and their behavior to others. That is a summary of what the right to privacy entails. And like other rights, it's also an enabling right. It's important for the realization of other rights. So for example, freedom of association is closely linked to the right to privacy, as well as freedom of speech. But what I want to emphasize is that the right to privacy has various facets, which sometimes are, misconstrued. So we have bodily privacy, for example. So you have a right to insist that you don't want to undergo medical examination or that kind of thing. That's the right to your body, to have control and autonomy over your body. But there's also territorial privacy to say, in my home, I don't want anybody to maybe trespass or to come and do ABC in my home. Those two aspects are not what we're really concerned with today. What we're concerned with today are the information privacy, which really is about your personal information that exists. How do I make sure that nobody unlawfully tampers with such information? And then obviously also communication privacy. When I send an email, when I interact with people, am I sure that this information is protected and is not, unduly compromised? So those are the four main aspects of privacy, I think. And then we are sort of going to narrow down on information and communication privacy for the purpose of this discussion. So also to highlight that because of the growing importance of the right to privacy as a human rights issue, the UN just 2 years ago decided to create a special mechanism, one of the special procedures on the right to privacy. And his mandate is to, along with other issues, identify obstacles and promote principles and best practices for the promotion and protection of the right to privacy at the national, regional, and international level. So this is just a diagram to show, and not by any means am I trying to indicate that international human rights obligations are more important than the regional ones, but just to show that we have those three tiers, of obligations. We have the international, mostly like in the UN system. We have the regional, the African Union and all its treaties and bodies and all that. And then we have the sub-regional level, which although they are mostly originally regional economic communities, are now increasingly engaging on issues of human rights, democracy, transparency, and governance on the continent. And then for the domestic level, obviously we have our laws and constitutions, and obviously for Nigeria, the Constitution, Chapter 4 on fundamental human rights is the most important. And also to identify that most constitutions will identify within their provisions what the role or what the place of international law is within the legal system. So for example, the Constitution of Nigeria will say, for example, that if you sign a treaty at the international level, it doesn't just automatically become applicable. There has to be a process that you go through to incorporate that treaty into your legal system, but it varies across board. So now I just want to highlight the development on the right to privacy from the ICT, not so linked to human rights framework. To say that, we've had data protection laws since 1970 in Europe and then to America and then in Europe as well, and that there have been a lot of instruments that have been adopted by the Council of Europe, the European Union, the OECD, within the EU, the most important one, which is what a lot of African nations have borrowed extensively from, is the EU Directive on Data Protection of 1995. And in terms of international human rights framework, we have the Universal Declaration of Human Rights, which obviously is not a binding document, it's just a declaration, but obviously has become so widely accepted that it's now customary international law. And we have the ICCPR, which is very important in Africa's context because all states, 53, have ratified it, except Comoros and Sudan. So whatever is contained in there is is quite influential in the way we relate on the issue of privacy. And both these instruments have provisions on the right to privacy. I'll skip this. And like I mentioned, unfortunately, the key African human rights instrument does not provide for the right to privacy. And I think there is a very good reason to that, because at the time the Charter was being developed, there was this keen desire to have a very uniquely African document. So you will see that, for example, in the Charter, unlike other human rights instruments, it talks about people's rights. You don't have that in maybe the ICCPR or other human rights documents. So they were trying to say, there's no right to privacy in our context. We believe in communal living. You are free to poke your nose into everybody's issues. That is my interpretation of why there's no right to privacy there. But obviously, it's also a misunderstanding of the different facets of the right to privacy. So it's not only about territorial privacy or your bodily privacy or whatever. There are different facets. But for reasons best known to them, they decided we're not going to have the right to privacy in the Charter. So the key thing now is, how do you then try and make sure that right is respected and is given flesh within the African human rights system when you don't have a basis within the African Charter? So there's a loophole. The African Commission, which is the body that interprets and oversees implementation of the Charter, has, in trying to flesh out what freedom of expression means, has inadvertently now gone into the realm of personal information. But it's a very little sidestep. They have said that you have the right to access, update, and correct your personal information, which I think is actually a little room, but at least still room for one to engage with that system. So for this reason, obviously, the issue of data protection has received very little attention within the African human rights system on its own. For example, the African Commission hasn't engaged with it, the African Court hasn't engaged with it at all, from a human rights perspective, I mean. So, like I said earlier, the use of now personal information is obviously strategic. Try and make sure that you don't get, like I got at the Commission, that data protection is not an issue. The right to privacy is not in the Charter, it's none of our business. So the only way I believe, or we believe, you can get this issue onto the agenda of the African Commission and other human rights bodies within the African Union is to go through the route of personal information, and how that you then flesh it out will depend on how receptive they are to the whole idea. So just to do a brief run through what exists across the continent. So ECOWAS, till date in Africa, is the only sub-region that has a binding data protection instrument in force, because it is ECOWAS revised its treaty, and in revising its treaty, it then attached protocols to the treaty. So you don't have to actually then ratify these protocols. They automatically become applicable. But this process started with, initially, there was a project, I think, with the EU to harmonize legal frameworks on ICTs within ECOWAS. That took place between 2005 and 2007. And then in 2010, there was a supplementary act on personal data protection that was adopted by ECOWAS, which is very heavily framed on the EU directive of 1995. And from that, you can already see that it's 1995, and this was done in 2010. So obviously, a lot of years have passed, but still, they're basing this document on something that was that old. And then within the EAC, what we have is there's an EAC framework on cyber law, also adopted in 2010. It is lacking in depth. It just talks about, states adopting international best practice on data protection. What that actually entails is very, very vague. And then in SADC, we have the SADC model law on data protection, which was adopted in 2013. And this was as part of a process led by, if I remember correctly, I think it's the EU and UNCTAD that started this entire project about harmonizing data protection laws across the continent. So it was done per region and also per country. And for SADC, they came up with a model law on data protection, which has very good provisions compared to what we have in ECOWAS and other regions. So for example, it talks about the rights of a data subject who is a child, which you wouldn't find in other frameworks. It talks about trans-border flow of information, it talks about notification for security breaches and also whistleblowing provisions. Very, very progressive. But the catch is it's a model law, it's not binding. And it's only, something that can be used, technically speaking, by the 15 SADC member states. So even though it's progressive, there's not much impact it can have across the continent. And then we have ECAS and CMAC, which also had the Gordon model law, just like the SADC model law. And then for CMAC, it was draft directives, which obviously carry less weight than a model law will carry, if at all. And maybe it would be a good point to also talk a bit about something I'll refer to much later on, about the process through which some of these documents were adopted, which also reflects some of the disconnect that one will see in terms of how the policies, how the legal framework runs. So for example, the SADC model law on data protection in reality was not even sort of like a homegrown thing. It was, so I got this, so I met someone, this is an aside, who I had seen from my research had been involved, I thought, in drafting the SADC model law. So when I meet her, I said to her, some provisions in that model law are really, really interesting. And she says to me, no, that's not really my work. I came in at the very tail end. The work had been done, it had been drafted. When they then realized, oops, we need someone who is local, to speak the language and sort of, make it feel like it's actually a local thing, then she came along. And she said it was so bad that the drafting was done by someone who was, I think, Belgian or something. So even the language was bad. And some of the requirements were just unrealistic, given the African framework, And that for her to actually be able to suggest any changes, it had to be that it came from, so they were running workshops in specific countries around Southern Africa. She had to indicate that it was the state representatives that had suggested that something be changed. She couldn't just, of her own accord, say, this doesn't work well for us in Africa. So that also shows the dynamics when these things are being drafted. And then I would just like to move to the African Union Convention on Cybersecurity and Personal Data Protection. So unlike all these other ones that I talked about that are sub-regional mechanisms, this is actually, Africa-wide. So it was adopted in 2014, but we have only one ratification since then. We've had only one ratification, which was just last year. And for this convention to come into force, we need 15. So 8 states have signed, but they're yet to ratify. And then obviously the positive question is, why haven't there been more ratifications? This is a topical issue, it's important, it's something we think we should be working on. Is it because of the lack of advocacy by CSOs or other stakeholders for countries to ratify it? Or do countries have problems with the provisions? That is something that one needs to engage with countries individually on. But what I can say is that this document is like what we have in ECOWAS, a conglomeration of 3 different issues. It's on electronic transactions, on data protection, and on cybersecurity. And the question for me, obviously as a human rights person, is why do we need to lump these 3 up in one document? Wouldn't it be fine to have them separate so that you can deal with them individually based on all the issues that would arise, and you will deal with them properly? But they saw it fit to do it this way. And I will also say, this is just conspiracy theory, that it was probably part of the influence of the EU or other donors that said, we have this wrapped up, we have it in ECOWAS, just take this and do it the way it is. I don't know, that's just my theory. And so when you look at this document, it looks very much like, or rather, it looks very much like the ECOWAS Supplementary Act. It looks very much like the SADC model law. And like I said, draws heavily on the EU directives of 1995. So that they're like children of the same mother. So basically, what does this document aim to achieve? It aims to establish legal frameworks to strengthen the protection of rights related to physical data and to sanction violations of the right to privacy. Question is, what is physical data? It's not defined in the convention, so your guess is as good as mine. It also has a very interesting objective about ensuring that data processing respects the rights of natural persons while protecting the prerogatives of states, rights of local communities, and purposes for which businesses were established. What that exactly means, your guess is as good as mine. I have no idea. So just to run through very quickly some of the key provisions of the convention. We know there are usually basic principles governing processing of data. So the convention identifies, I think, 6 of them. One is consent and legitimacy. The next is lawfulness and fairness. Basically that it must be done, processing must be done in a lawful manner. It mustn't be fraudulent and it must be fair. There's also the principle on purpose, relevance, and storage, which speaks to processing being done for the purpose for which it was actually collected. Also accuracy. The data you collect must be accurate and it must be updated to make sure that it's accurate. And as far as it's reasonable possible, inaccurate or incomplete data must be erased or rectified. The principle of transparency. Those who control data must disclose information on personal data that they hold. And finally, confidentiality and security. Personal data must be protected, especially where it involves transmission of data over a network. So there are also other formalities. So for example, what kind of information can you process without permission, and what process do you go through? What happens when you have sensitive personal data? So what is termed sensitive personal data under the convention is information that relates to state security, defense, public security, the prevention, investigation, detection, or prosecution of a criminal offense, or execution of criminal convictions or security measures. Others include racial, ethnic, regional origin, affiliation, political, philosophical, or religious beliefs, trade union membership, or data about your health or sex life. So just as an ATI person, the moment I see state security and defense and public security, alarm bells start to ring. Because we all know that state security is often, national security is often the trump card that states would use to violate rights. It's with the trump card they use not only as a shield, but also as a sword. They will say, we are interfering with your privacy because we need to protect national security, there's terrorism, ABC. But we'll also use it as a sword to say this is why we need to get your information. But later on, we'll come to talk about that in more detail. And then rights of data subjects, obviously music to my ears. So the right to information. As someone whose information is being held by a data controller, you have the right to the identity of the data controller or his or her representative, the purpose for which the data is being processed, the categories of data involved in the processing, persons to whom the information might be disclosed to, to what extent can you request, for this information to be deleted, to what extent can I ask for this information to be updated because it's outdated or it's incorrect, and how long will you store this information for? And if you want to transfer it, who are you transferring it to? All these are rights that people have as data subjects. Sorry. And then the right of access. So obviously, to be able to protect your privacy, you must know what is being held, right, about you. Without that, there's no way you can find out if it's incorrect or if it's improperly being managed. So as a data subject, you have the right to know what information is being held about you. And that also allows you to evaluate the reason for the processing of that information. Also, you need to be able to confirm what data exactly is being processed, as well as information on the purpose of processing is similar to the rights of the data subject. And then the right to object, which is very important, to say, I do not want my data to be processed. But it says on reasonable grounds. So who determines if the grounds are reasonable or not is another issue for discussion. I guess it will depend on a case-by-case basis, but I think it would have been better to have some more clarity on what that will mean in practical terms. And then you have the right to demand that your data is rectified, if it's incomplete, that it's completed, it's updated, it's erased, or where it's inaccurate or incomplete for it to be updated, and all that. And then another key provision you'll find is the obligation of data controller. So whoever holds your information, your personal information, should ensure that processing of that information is confidential. It's not, done in a way that it compromises your security. To also make sure that your data is prevented from being altered, destroyed, or accessed by unauthorized persons. And also linked to the rights of data of subjects to ensure that the information that is collected is stored only as long as necessary and only for the purpose for which it was collected or processed in the first place. Yeah. And then, so the key body that will then oversee the implementation of these provisions is the National Data Protection Authority. So it's established, they recommend that it's established, it's independent, and crucially, provided with the human, technical, and financial resources necessary to accomplish its mandate. One very interesting provision that I see there is that it stipulates that membership of that body should not include members of government, should not include business executives or shareholders in ICT and in the business sector. Why? I don't know. So now I'm done with looking through the AU Convention. So now just to come down now to the domestic framework on privacy and data protection. So as we know, data protection is a very, very recent, issue. So you will not find in constitutions across the continent, especially the older ones from like independent constitutions, a right to privacy, sorry, a right to data protection, independent of the right to privacy. You'll find the right to privacy and then you'll just, interpret it in a way that gives effect to data protection. But because now we've been changing constitutions recently, there are few countries that have now included data protection on its own as, a right in the constitution. You will see, for example, that 3 countries out of 55, yeah, that's very few. You have Algeria, Cape Verde, and Mozambique that have provisions on data protection in their constitutions. So Algeria is very, very bland. It just talks about protection of the personal data as a fundamental human right that must be guaranteed by a law. So in essence, adopt a law and make sure that personal data is protected. But for Cape Verde and Mozambique, the provisions are quite detailed. It talks about the rights to access, rectify, and update, your personal information, how you process sensitive data, how you must enact a law to give effect to protect personal data, and also access to and transfer of personal information is prohibited by law, except in accordance with the judicial decision. Mozambique is very, very similar as well. It has the same kind of provisions as Cape Verde has. So that was looking at information privacy, data protection on its own in constitutions. Only 3 countries have that. But when you look at communication privacy, which was the way privacy was framed initially within independence constitutions, then you have a lot of constitutions talking about privacy in a very broad manner, to say the right to protect privacy of correspondence or communication or secrecy of correspondence. But the beauty of human rights is that you can always read in and expand rights without the need to then go in and create. I mean, how difficult is it in most of our countries to adopt a new constitution? That usually happens when there's a big crisis, there's transition, so it's not feasible to expect that you can then update all our constitutions and have, these provisions in there. So you have to be creative and, broaden whatever exists already. So you have a variety of provisions in constitutions talking about communication privacy and how you must protect that, which, like I say, can be expanded to include data protection as is seen fit. And then moving on now to the laws actually we have on the continent. So we have about 16 now, Cape Verde being the first as far back as 2001. We have 15 other countries listed here that have data protection laws. And I'm not going to go into this. This is just some of the key provisions you will find, in these laws. They define personal information very similar across, all the laws. Also, another issue is about how the scope of application of the laws. Does it apply to both public and private institutions? Yes, in most cases. And also, how does it apply in what, like in terms of territorial applicability? So does it apply only to processing in your country, in the country concerned, or how does it work? So there are a few examples here. In Seychelles, for example, it applies to data processed inside that country and any data processed outside, but intended to be utilized in Seychelles. Ghana, Madagascar, and Mali, information, it's about information that takes place, processing that takes place wholly or partly within the territory. South Africa, as always, is always unique, talks about processing that is based in South Africa or through a process that is automated or not automated through means in South Africa. So what means exactly means is your guess is as good as mine. And then also formalities, consent, like we discussed, and then how they qualify consent. In South Africa, it says voluntary, specific, and informed expression of will in terms of which permission is given for the processing of personal information. This is very, very specific. It has to be voluntary. It must be specific. It can't be a general thing to say, I will consent to anything you do. No, very specific. And then it must be informed. You must explain exactly what the entire process is like. And then Teki alluded to this earlier, that usually it's rare, but some of the laws require that you register with the Data Protection Authority. So in Ghana, in Mauritius, in Seychelles, and I think in our common law jurisdictions, that's the requirement, but not in the other countries. So what happens is that many times you need to get prior authorization of the BPA to process personal information. And some countries have good provisions saying, for example, that you need to develop codes of conduct on processing. We have that in Cape Verde, in Mauritius, and in South Africa, which would then help data controllers to know exactly what they need to do, and everybody is clear on what the obligations are. And then there are also exemptions, which I find problematic. So you will find some laws will tell you that there are certain categories of information that certain provisions in data protection laws will not apply to. So for example, in Ghana, you have a provision that says that when it's a national security issue, then you cannot apply the rights of the data subject. And then how do you say it's a national security issue? It's a certificate that is issued, I think, by a minister saying that it's a national security issue. And that means it's conclusive. Although there is, if you are offended or if you have problems with the way that has been done, you can approach the courts for a review of that. But that is very, very problematic for me, especially as in the ATI field where national security is always used as a trump card, like I said before, to say this thing, it's national security, we need to check, you know, that's why surveillance is being conducted, because of national security grounds. So without having a way of sort of reviewing that, in most countries it's very, very problematic, because then they just use it as a trump card and then all your rights are, you know, dispensed with. Also, security breach notification is very, very important to know when the data has been breached. Most laws don't have that in place. Some do. Ghana and South Africa has that in place. It should be a requirement that once it comes to the attention of the data controller that your information has been breached, that you are notified. So you can then take the requisite measures to, you know, make sure that you don't suffer any irreparable harm. And then, so these other principles are principles that have been discussed previously with the AU Convention. I'm not going to mention them. I'll just skip to the trans-border flow of personal data, which it was mentioned earlier. Most laws will tell you that there needs to be, you can only transfer data to a country that has an adequate level of protection. So who determines what the adequate level of protection is? It varies from country to country. So some laws will give you the details of how it should be done. But the fact is that if you don't also have a data protection law in the other country, then how do you really say you have an adequate level of protection? That, I think, is problematic even for within Africa, for trade and for other issues that we need to, you know, to work on as a continent. And then finally, on data protection authorities, you have them set up across the continent in all the laws. But most of them are multiple member commissions. They are not commissions. Except in Mauritius and Seychelles, where you have a single commissioner, and then obviously a secretariat supporting their work. And Ghana has an interesting system, a hybrid system, where you have like the governing body that gives direction, and they now have the director that does the day-to-day running of the organization. And just based on best practice from the ATI sector, it's believed that it's better to have multiple, members. There you have, wide array of expertise and skills, and then people can bring that to bear as they implement the law. Okay, so I just want to identify some of the gaps that were noticed, just looking at the regional and national legal frameworks that have been discussed. The exceptions, like I said, it reveals a worrying trend that your rights as a data subject are automatically overridden once it's a national security issue. That is problematic. There should be a way of having a more balanced, objective way of assessing and saying, is this really a national security issue? And what steps can be taken to then ensure that even as a national security issue, my rights are still protected. So that is what is discussed there. And then when you look at what we have, the AU Convention, the ECOWAS, you will see in the preamble maybe reference to privacy as a right. But that's where it ends. You don't really see much engagement with the link of ATI and privacy, which are very interlinked, like I mentioned earlier, on issues like national security and how that has been dealt with in the ATI sphere. And I think also it creates a perception in the minds of everyone, including those who are going to implement the law, that there are no human rights considerations at play here. We take the law as it is, it's technical, it's ICT, we don't really delve into the human rights considerations. We don't look at what ICCPR says, what a special rapporteur on rights privacy say, what other human rights standards that exist in implementing these frameworks, which is problematic. I've already mentioned exemption issue. And then, like I already alluded to, reliance on dated standards from other regions. I think that is a big problem. If in 2010, with the way the ICT sector is constantly changing and things are just moving within 2 months, things have changed. If you're going to rely on something that was drafted in 1995, in 2010, or in 2014, that is clearly a problem. Especially when those people who designed that have actually updated that framework, itself. We talked about the new EU framework that has been adopted since 2016, but it's only coming into effect in 2018. It contains a lot of innovative, and important provisions, which obviously we don't have in our legal frameworks. And I think probably one way of carrying that, because like I said, ICT is constantly changing, is to have a body that implements that is also, like I said, has a lot of people with expertise, and is given the room and latitude to then innovate, create regulations and things that will then make things, move with the time, so to speak. And then another issue noticed within the convention is that there's no regional mechanism to monitor its implementation. If you look at it, you will see that there is, I think the chair of the AU can establish some committee. But when you look at the functions of that committee, it's about cybersecurity, simplicity. So I'm not sure if the idea was to have that same body double, but it's not clearly stipulated, and obviously then you cannot really run with that. But it's very, very important that you have that, because left like this, it means you have local data protection authorities left to their own devices. Nobody supervises and says, are you really implementing the laws the way they should? The way you want to have a human, a regional sort of supervisory mechanism looking down and making sure that everything is going on fine as it should be. So that is an obvious gap within the convention. And then just to move to some of the recommendations that came up with the research. So because we have almost all states in Africa as parties to the ICCPR, that obviously provides a good mechanism to engage with these issues of data protection. So we have the Human Rights Committee that looks at the reports of state parties every 4 years. So obviously for CSOs, it's a perfect opportunity to then say, what are so if you don't even have a law to start with, that is an issue. But if you have a law, then you say, what are the gaps in the law? What are the challenges to implementing that law? And just engage with that process and make sure that states are sort of forced to look at what they're doing, in terms of not having a law, or having a law that doesn't really meet the criteria that's set up by the ICCPR. And then, like I said, there's a special rapporteur on the right to privacy, to what extent, and part of the work of the social rapporteur is to see what the gaps are and engage with states and help them implementing the right. How does one then engage with this mechanism and see that you draw attention to whatever issues are existing in whichever country you want to highlight, or even if it's a region as a whole. And then the UPR process is also a very good opportunity where countries do sort of like a peer review, like the APRM, and look at what steps have been taken. How do we then engage in that process as well to make sure that data protection becomes a topical issue? In terms of Africa, like I said, Morocco is the only party that hasn't. It's just rejoined the AU, so we're looking forward to Morocco ratifying the charter. But I mean, one way forward could be to develop a model law for Africa, which will look at all the gaps identified, you know, regionally and nationally, and then see how we can then use that to develop, you know, better data protection laws on the continent. And then, in a sneaky way, infuse data protection issues into the work of the African Commission. So far, they've resisted. There seems to be a little window of opportunity. So if we, for example, put that in the state reporting process, so every 2 years, states are meant to report on the steps they've taken to give effect to the rights in the Charter. So require that states put in their reports what they've done to protect the right to privacy. Resolution by the African Commission. So it would be a dual-edged sword in the sense that it would give the Commission an opportunity to familiarize itself with data protection issues, like, you know, because before they adopt a resolution, they must know what this thing is, what this monster is about, you know, and at the same time give guidance to states on what data protection is all about and what they need to do in complying with the Charter. And then, even though the Charter has no the privacy provision, surprise, the Charter on the rights and welfare of the child has the right to privacy there, which is actually a good thing. So to engage with this mechanism, there's a committee of experts on the rights and welfare of the child. Engage with them on issues relating to data protection for children and see, you know, how that can become more pronounced as a human rights issue on the continent. And also engage with the African Court, you know, on human rights, as well as the AU Commission on International Law, which sort of tries to develop new principles on international law for the African region. And then there's the African Network of Data Protection Authorities, which is like a body of all the DPAs on the continent, you know. This also could be a useful opportunity or a useful platform, you know, to see how states learn from each other and try and get, you know, balance in the way data protection is implemented. And then Nigeria. So, I mean, not wanting to preempt the discussion that's going to go on tomorrow, just a few ideas on what could happen if we wanted to adopt a comprehensive data protection law. I know there are bills, there are like 2 or 3 bills, you know, already on the table. To borrow, please not rely on the EU directive of 1995, and borrow from the guidelines of the new one of 2016 from the EU, or the OECD standard of 2013, not to go back, you know, in time. And take into account the obligations of Nigeria in terms of ICCPR and other human rights, you know, instruments, in terms of developing whatever framework that's going to come up. And then also look obviously at the domestic legal framework, but in particular the FOIA Act. The problem I have with the FOIA Act is that even though it is meant to give effect to a human right, that is access to information. But when you read the Act, there is barely any mention of human rights in that Act. So you will see that even the earlier decisions that came about on from the FOIA Act, from the judiciary, they were just applying a law mechanically, not even thinking about the human rights implications, not thinking about what the purpose of the law was to start with. So you have, for example, generally a principle of ATI is that information should be accessible, it's irrelevant when it was created. But then the judge says, no, this law was created in 2011. Why should you then be able to access information that was created in 2000, for example? That is because they don't realize the actual purpose for which the law was adopted. And that's because the law in itself, when you read it, makes no reference to human rights in its provisions. So it's really good to, in developing a data protection law for Nigeria, see how you can maybe cure some of the defects in the FOIA Act, or at least make sure that you take into account how you address issues of mutual concern in both FOIA Act as well as in data protection law. And then maybe, as I mentioned, there are a few countries like South Africa that have one body managing both, as a way of balancing things properly, without there having to be power play and people feeling that they are more important than the other. Maybe Nigeria might want to take that route, and instead of having, like, now the FOIA Act is being overseen by the AG's office, which is definitely not ideal. You need to have an independent body entirely overseeing the FOIA Act. So maybe a possibility would be to have a new body entirely, or an existing one like the Human Rights Commission, to then marry both rights, that is ATI as well as data protection, and then make sure there's a clear balance in implementing both rights. Thank you very much.
Thank you very much, Dr. Lola Shailon, for that thought-provoking piece. We'll be going into the next plenary session, and I would like to invite Mrs. Tope Ogundipe to the stage. Can we put our hands together for her? She represents the Paradigm Initiative.
Good afternoon, everyone. As I said, my name is Tope Ogundipe. I'm a digital rights advocate, or maybe activist, more like it. I would engage in all the typically, how do I put it, activities of a rebel leader, like campaigns, movement building, even litigation sometimes of government and government agencies on issues around internet freedom. And I also do other things around capacity building, and or my organization does things around internet policy training, and also direct lobbying. We have a bill in the House that talks to some of these issues of data privacy and protection and freedom of expression online, which is making good progress, and we're also taking recommendations in terms of harmonizing with other efforts in this direction. So I'll be moderating today's panel on Dr. Shailon's paper, which I found very interesting. I typically find academic papers rather boring, but I found this interesting because of the human rights angle. So forgive me if the conversation leans heavily towards the human rights angle, but I think that from our presentation, I think I'm going to be going in the right direction because that seems to be the focus. So I'll just invite the panelists up. We do not have very much time. We are a lot behind in the schedule for today, but I trust that in the short time that we have, we'll be able to just highlight a few things and share our initial thoughts. And if we have more time, we could open up to the floor and have people also be able to ask panelists or Dr. Shailon, as you corrected me, Shilon, sorry, I keep Dr. Shilon herself questions on the paper. So I'll invite Barbara Imayo, Manager of Legal Services, National Information Technology Authority, Uganda, upstage. Enrico Calandro, Research Manager, Research IT, Africa. Professor Chris Seaborn, Deputy Head, Cybersecurity, Cyberware Intelligence and Operations. Barrister Chukwuyere Iziogu, Senior Advocate, Stream Sowers and Con. Our distinguished guests from government agencies, Executive Vice Chairman, NCC, Engineer Abubakar Mena, and Mrs. Chioma J. Oki from the National Information Technology Development Agency in Nigeria. Okay, so to start, I'll moderate from here since I didn't get a seat on the podium. So one of the things that greatly concerned me, reading that paper and also listening to her, is around provision of exceptions regarding issues of state security, defense, criminal prosecution, and all of that. It is very concerning, given the context of Africa and our history in terms of practices of government, which can be typically undemocratic and just high-handed sometimes. So when you look at the AU Convention on Cyber Security and Data Protection, the SADC laws, model laws, which she said are even very progressive, and the supplementary law, the ECOWAS supplementary law, which is binding on West African states, all of these have these provisions. In my opinion, without any provision for objective assessment for the application of these exceptions, these provisions for exceptions. So what are the implications of this for data protection and privacy on the continent? And what are your initial thoughts, about where it is possible to go from here, in terms of balancing issues of security and privacy, without, what language did she use? Trump card. Anytime there's controversial action by government, most of the time, around surveillance, more recently, pulling the plug on the internet, that's the card that is pulled out. State security, public order, and all of that. So what's the implication of this for human rights? And what are your immediate thoughts on how we can go forward balancing privacy and security? So where do I start from? Do I start from Barrister? Yes. There are two of the microphones, so one should be, okay, I'll give you mine.
Thank you very much. Thank you very much, Mike. I would like to correct an impression here. When she introduced me as a senior advocate. My name is Chukwunyere Izwogo. My friends call me Chooks, and I'm not a senior advocate. I'm a senior associate with Stream Source and Con. I practice telecommunications law and information technology. So I'll just go straight to your question. I'll speak from the Nigerian perspective. It's a constitutional provision that the state itself has a right to actually abridge certain human rights for the interest of states. So when we talk about data protection, we also look at the rights of everybody, the data subjects, to ensure that their personal information is properly accessed. And on the other hand, we also have the right of the state to ensure that law enforcement purposes are met in countries. So I think there are no fast rules about this. What I would say is that, in trying to meet state obligations, public interest in respect of for security purposes, there should be proper oversight. There should be proper oversight. There should be a body that is in charge of, okay, if the state needs to make an application to access data for law enforcement purposes, then there should be a particular body that is charged with that responsibility of properly scrutinizing such applications. One hand, we have interest of states protected, and also the other hand, we have, interest of data subjects not being unnecessarily subjected to the disclosure or the access of their personal information. That would be my first thoughts from a Nigerian perspective. Thank you.
probably won't interrupt everyone, but I know that she's from NITA, and I'm particularly interested in her thoughts around legal framework. You know, what would you, because some of the time when we have these conversations and engagement with government, it's, you know, like you said, it's usually a tension between the duty of state and the privacy and protection of citizens' information. But I would be really interested in what your thoughts are for what would you suggest in terms of legal framework around government actions when it comes to issues of surveillance and interception of communication, you know, because right now I'm not really sure that we have anything that sufficiently protects Nigerian citizens, if I'm, you know, since you're from NITA in place, yeah.
Thank you. We all know that Nigeria does not have any Data Protection Act at the moment, but the Constitution in Section 37 actually guarantees the right of privacy for citizens, their homes, correspondence, telephone conversations, telegraphic communication. It guarantees and protects it. We also have some industry specification like the NCC practice regulation. We have the Section 8 of the Child Rights and Section 14 of the Freedom of Information Act. These regulations stipulate limits to which you can use personal information of citizens. NITA has guidelines on data protection, and it's probably the most comprehensive regulation that contains specific and detailed provisions on the protection, storage, transfer, and treatment of personal data. These guidelines, however, apply to federal government, state, and local government. But I would like to, you know, why we found it interesting to attend this seminar is actually because this guideline is undergoing a review, and at the appropriate time, the rulemaking process actually stipulates that would involve stakeholders, some of whom are here in that process. And this review will ensure that these guidelines on data protection would bind not just the public sector, but also the private sector. Okay, I want to comment about this issue about, you know, state versus the right of the individual to privacy. We can't take anything away from the fact that sometimes national integrity and defense needs to come, you know, before private rights sometimes, but it's how to balance it. Like the Freedom of Information Act in Section 25 actually gives the court the right to determine when an MDA is saying, I can't give you this information. The court can decide, really, in withholding it, are you serving a greater public good or not? And the court can rule in favor of an individual. I think there's no perfect law, but the laws that we have, how hard have we pushed those laws? You know, advocacy is not like about coming to seminars and saying this is what ought to be. How do we challenge the limits of the existing laws? You know, I'm an FOI practitioner because I've done like Dex work on freedom of information. And I noticed that sometimes you give information to people and then they say, okay, that's very nice. Sometimes you say no. They don't come back to say, why did you say no? Even the NGOs themselves. So I think we need to like sort of like, you know, we need to push the boundaries of jurisprudence. You're not going to have decisions if you don't take matters to court. Thank you.
Thank you very much. Thank you very much for that. That's an interesting angle. I introduced myself as some sort of rebel leader. I have a couple of cases in court around the FOI request. I just made a request to NCC regarding the report of IT Realms and Tribune concerning the directive to shut down certain websites in Nigeria. I'm yet to receive a response officially to that, but I did get, there's a 7 days limit within which information, so after 7 days we got a mail saying that they will still get back to us or something like that. But just to know that that's something we've done. FOI requests for us has not been a very successful thing. We have multiple litigations and course around these issues, and we will continue to do it. Thank you. Okay, so Professor Stevens, I'm putting out there, you know, just to say that sometimes it is also important to have regulators in the room and have the importance to talk to the importance of these issues, so that when we make some of these requests or try to use already existing laws, we can have a lot more cooperation with people like you, who we have had conversation with around the issues inside. So Professor Sibon, you corrected me earlier that the S is extra. My original question, do you still remember? Yeah, so I started to ask, and I still intend to go around, about the provision of exceptions in all of these laws, the legal framework, in Africa generally around data protection, in local laws, in AU Convention, and some of the laws, regional laws that she has mentioned. There is that provision, with for exception with regards to state security, and without, in my opinion, adequate provision made for what I would call an objective assessment of when it is right to apply this law. So I was asking what your thoughts are concerning that, and what you would recommend as a way forward concerning these issues.
Okay, I think for a start, I mean, I was looking at the Constitution of Nigeria just a few minutes back. I was about to say the same thing as my colleague here, and it's pretty clear, actually. The privacy of citizens, their homes, correspondence, telephone conversations, and telegraphic communications is hereby guaranteed and protected. Additionally, as a member of the United Nations, Nigeria is bound by the Universal Declaration of Human Rights, which states in Article 12, no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. So everyone has the right to the protection of the law against such interference or attacks. If I read that, I've already answered your question in one way. No. Okay. What I would like to say is, when I was reading through it and I'm looking at it, you guys should be happy, because not many constitutions around in Africa would you see this kind of wordings imprinted in there. I would probably say, if I were in the U.S., I'd raise the First Amendment, my right to say whatever I want to, whatever. But I mean, Nigeria is one of the rare, I would say, that's my personal view, where you have this kind of thing in the Constitution. That is not in the Constitution in Mauritius. That is not in the Constitution of many countries. It has happened. I think you should be taking that as one of the main things. I mean, people need to understand the Constitution of their country. And I've found one of the things that in many countries we tend to forget is we don't know our own Constitution. It is very important that even in Africa it's even worse. I mean, I was in high school in the US and I had to learn the Constitution of the United States. What it does, what it says, how the Senate works, how everything works. And I found by going around in many countries, people don't actually even look at their constitution and what are their real rights. And when the problem arises, then you go to court, you can't even figure out whether you really had to go to court or it could have been solved differently. It's today a mess. Let me put it that way, it's a mess. We need to get, I mean, we've got students here, they need to, aside from whatever they're doing, understand the constitution of their own country. And that also implicates any bills that passes that supports, your privacy. Privacy is very important. I mean, I was just reading Times just yesterday, and I hope my good friend Sunday was saying something about Facebook. Now, do you know that Facebook has actually started face authentication by camera? Right? So the minute you go through a camera system and that's there, it would actually connect that person to the profile on Facebook. How is that? How's that to your privacy? Now, the other interesting thing to that is, it doesn't say whether Facebook is gonna make sure that those who actually take privacy as a setting is not gonna appear there. It only says it will make sure that once you identify your image, your picture, it will track you to the profile that you have in place. So Facebook profile will come up, and suddenly probably LinkedIn will probably crop up, and a lot of things would actually happen. So if we're talking about privacy, we've got a situation in hand. What will Facebook do in Africa? And I can bet you most of the governments would actually go for it because this is what they want to know before you actually pass immigration. And where does your right go in there? It's a question that we have to pose ourselves. How much of information do we give out? I mean, earlier I was talking to our good friend from Google. I mean, you know, when we read those long agreement, you know, and you go down there and just click agree, do you know that it actually talks, I mean, certainly from companies in the US, like Google, Microsoft, any software that's produced in the US, they've got specific stuff written in that agreement, which says you cannot, for example, install Microsoft Office or Windows in a radiation unit, like you know, a nuclear reactor or whatever, which is closed. Nobody reads that. And it also says countries which are listed, blacklisted, you know, by the US, it's also in there, but nobody reads it. Then you just go and click OK. And now, the problem about privacy is how much information do you want to really give out? And when you look at GDPR is not new. It's been there for ages. It's just the Belgian law and obviously the Netherlands law, which has been put together, and some changes made to it. I met with them just last week, actually, and I just asked them one question: what's different? You know what was the answer? We are just enforcing it now. That's the answer. There's nothing new to that. Well, a few changes. Of course, there's the enforcement by making sure you pay a lot of money, which is a deterrent. It's like in a house. You put a camera, even if it doesn't work, a thief comes in, looks at the camera, says, no, I'm not going to go in there because there's a camera looking at me. It's a deterrent. Now, coming back to Africa, the single solution, I was just talking to our good lawyer friend there. I mean, we were looking at it. I'm working with the Mauritian government right now. We're going to we've got the Data Protection Act. We've got the Data Protection Commissioner. What we've decided is we're going to sit down, we're going to overhaul the Data Protection Act completely, either, you know, rip it off, and take the GDPR, modify it just like the UK has actually done with their own. So that's one of the options. And the second one is, I was trying to tell them, you know, we could actually do it even this easier way. Let's keep the Data Protection Act because it already covers whatever's in there. Let's add one line, an amendment to that Data Protection Act, which says we are going to align ourselves with the GDPR rules in place. How about that? Does it need a lot of change? Is your government going to do that? It's a question. So that's the easiest way of doing it. You don't need to rewrite everything as well. You just say you're going to align to that. Legally possible. It's not, and the way it's done, it's so simple. But this is also what I was looking at, and I had to go for a course earlier this year in GDPR, just to understand what GDPR is all about. 5 days course. Yeah, it's okay. So the course was 5 days. Then they said 2 days you can actually go out. You don't need to study it because you just had to understand all the applications and all the whatever, mumbo jumbo. So went there after 3 days, listened to all the different articles in there, and I came up with a workflow and an Excel sheet that actually tells you, if you are in this industry, you click on it, these are the stuff that you need to do for yourself. Then I went back to the guy who was actually doing the training, and I said, what do you think about this? He said, can you give it to me? I will use it for my next courses. I said, well, there's intellectual property on that. If you want to pay for it, pay for it. I'll get back to the other details afterward.
All right, thanks. I hope, Enrico, I don't have to ask my question all over again.
Do you remember?
Yeah.
Thank you for remembering.
Okay. Well, I believe that, I mean, the states are in a privileged position in this kind of debate because, of course, they set the rules and they create the standards, right, on what is right and what is wrong in data protection and in the privacy of the citizens. So the risk, unfortunately, with that is that in authoritarian or semi-authoritarian regimes, there might be a abuse of power, right? And so these exceptions actually might not be towards the protection of citizens or, you know, for safety and security, but for different reasons. Of course, all countries have got mechanisms in place in order to keep them accountable somehow. Also, I mean, they're not always implemented. But the main problem that, for instance, we're trying to explore now, current internet research at City Africa is actually what's the level of awareness of privacy between the citizens? Because, I mean, these discussions most of the time are, you know, between legal experts, practitioners, sometimes you find activists, civil society organizations, but the citizens are completely excluded. And having a look at the initial data from our national representative surveys across 7 African countries, we actually find out that there is an incredibly small percentage of people that know what privacy is and they've got any concern of privacy on the internet. I mean, the main reason for using the internet or over-the-top platforms, free services, is because they are free and they are cheaper than you know, a traditional voice or SMS services. So that's the main reason why, and that's the main concern. It's actually their price stays for free. And, you know, they don't have to pay for that, and so actually there is not awareness on you know, what can be exceptions or what are the national security issues and so on and so forth. That doesn't create the kind of accountability, right? That it's there needed for the states to behave in a proper way. So I believe that's the main problem that we have. So we discussed this morning that it's important to do capacity building, training, awareness, you know, at the government level or at an institutional level for those that actually have to enforce this kind of legislation, so on and so forth. But also in the population, I mean, it's very, very important and relevant for small and medium enterprises. I mean, I think we're going to have a huge crisis next year. I believe most of the African SMEs and informal sector will be a huge embargo. It won't be possible any longer to trade with Europe, because I believe that it's incredibly complicated, expensive to be compliant with that legislation. And it seems that from a regulator, from a government state perspective, those issues are actually not taken into account at all.
Great, thanks. Thanks for your contribution, Eric. Barbara?
Hi. Back to your question, what comes to my mind about the inclusion of exceptions within the data protection and privacy laws is, first of all, they create a lot of distrust amongst the citizens and data subjects. So when there's a lot of distrust, people worry about how is their data being used. Of course, provisions like national security, which, for example, in Uganda is one of those provisions within the Constitution of Uganda under Article 41, that would be an exception where the privacy of a person might not be considered. For me, I think the consideration that could be made in trying to get this is to build trust and boost transparency amongst the citizens, that their private data, personal data that is held by government is at all times being used for the right reasons and not being misused. And then there's so many different ways of bringing on board the citizen to ensure that they have that confidence. I'll take an example of Estonia, where it's very clear that a citizen enters into using their mobile ID, and can see who accessed their data at any given time, what they were accessing their data for, and that boosts a lot of confidence that the data is probably not being misused, but being used for the right reasons. And then also the use of the different laws that are complementary laws, for example, Access to Information Acts, can also help safeguard against the misuse and the misuse that the citizens worry about, the surveillance and all that, because if someone has to access that personal data, you probably have to find a way of accessing it legally rather than just in an arbitrary manner, so that still the citizen feels comfortable at all times that their personal data is being used for the right reasons.
Thank you, Barbara. Engineer Maina?
Yes.
Yeah.
Thank you. I would first want to clear the fact that when I was ushered in as the Executive Vice Chairman, I want to correct that impression. I'm representing the Executive Vice Chairman, Professor Umar Garba Dambata. I head the cybersecurity unit of the Nigerian Communications Commission. As you are aware, the NCC is a regulator in the telecommunication industry in Nigeria, and we are a government agency. With respect to private data, our concern mainly is about the possible breaches to information, personal information collected, such as unauthorized access, misuse, or identity theft. And we should note also that the vast majority of the nation's communication infrastructure, which we regulate, resides in private hands. The industry is 90% private owned. The risk, therefore, to national and economic security associated with the compromise or failure of these assets mean that their protection requires concerted public, private, and government partnership and efforts in protecting the information that resides in the hands of stakeholders in the industry. Our concern as regulators basically is about the possible misuse of this private information. We are also concerned with the need for agencies and organizations to provide convincing assurances that personal data collected by industry players are hosted or kept in secure locations. And particularly for the consumers, the Commission is also concerned about abuse of users' privacy via what we call unsolicited messages or calls in the form of adverts and such reasons. And to mitigate against some of these, what the Commission has done, first and foremost, is it has come up with the Consumer Code of Practice Regulation 2007, which is a regulation that takes steps to ensure protection of customers' information against misuse and disclosure, or improper disclosure. The telecom industry also came up with what we call the Do Not Disturb Registry, via the collaboration with the service providers. This empowers consumers to have the right to demand that certain calls or messages do not get to them. This is also our own way of curtailing the instances of unsolicited messages. In terms of our collaboration with security agencies, of course, as government agency, our stand is to have a kind of balanced and multi-stakeholder approach to personal information protection. The Commission has come up with, for instance, a guideline on lawful interception,
Thank you. I was going to ask that. Permit me to interrupt you. I'm not sure that you'll be able to read the entire paper because of the time that we have on this panel. But I was just going to I was waiting for that because you were mentioning some of the draft regulations, and I was waiting for that one on lawful interception of communication. And I want you to speak to that a bit, especially if it has any provisions for judicial oversight of how citizens' communication is intercepted.
Unfortunately, I may not be able to give you those details. First and foremost, the guideline is still in its draft form. It has only gone through the first stage of what we call public inquiry, where all stakeholders, including NGOs, the MBA, law enforcement agencies, the industry stakeholders have scrutinized the document, and it is yet to reach the final stages of gazetting and the rest of it. And
okay, so we hope to see some of our recommendations here reflected, and those that we discussed with you in that meeting.
Yeah, the scrutiny is still on. You can still get the site of the drafts on our website.
Great.
And also make inputs.
Thank you. I'm sorry I had to interrupt you because I just want to see if I can go around one more time. I'm not even sure about that. Depends on how quickly the panelists answer the question, and then maybe we'll take a few comments from the audience. So I wanted to pick on the issue you started to mention about 90% of data being in the hands of industry and private sector. And what I'm coming to you now, barrister, senior, no, not advocate, senior associate. Yeah. So the extent of responsibility of private sector around requests, at human rights due diligence, when it comes to, and maybe also remedies to affected persons, when it comes to state requests for data of citizens. Okay, so what is the extent of responsibility? What would you recommend as this is standard operating procedure, in terms of, when it comes to state requests concerning citizens' data from industry, from private sector, so what, and again, I'm speaking to not just issues of, okay, you already understand, all right, thank you.
Thank you very much. I understand your question now. Like I always do, I'll speak from the Nigerian perspective. In terms of, I'll give you a scenario, a typical scenario, for law enforcement purpose, when we're talking about wiretaps and lawful interception. The usual practice in place in Nigeria as at now is normally sometimes you have to actually apply to the court for some sort of authorization and order to have access to such information, through a court order, because the private sectors, sometimes they're actually trying to mitigate their exposure to liabilities from people who actually are aggrieved if their personal information is given out without proper court order. So that's, like I would say, that's what the standard operating procedure looks like in Nigeria right now.
How about issues around transparency, disclosure? Do you think that in certain circumstances, it should be published what kinds of information government is asking?
Okay, yeah, that makes some sense.
Should it be published? What kind of information? Should it be transparent? What kinds of information government is requesting from, say, Google or Facebook or smaller SMEs, even in the country? Do citizens have a right to know if government is requesting their data?
Ideally, from a human rights perspective, from a constitutional perspective, citizens have a right to know. But the challenge we have right now in Nigeria is that there is no data law, because one of the main elements of data protection statutes is the element of the right of access, transparency of using personal information. So, but absent that in Nigeria,
and we are all in danger.
That's one of the major.
Yeah, so I'm trying to get you paranoid so that you can all become advocates like me.
So that's one of the data protection risks we have in Nigeria. I'm going to talk about this tomorrow from a Nigerian perspective. Thank you.
Great. Thank you very much. So I'm going to come to, I need to look for the name. I'm sorry, but the representative from NIDA. And you started to talk around issues of accountability and compliance. And maybe I would just want to, there's this thing called Pick Your Brain on what further thoughts do you have? One of the challenges that I saw from reading Dr. Shillong's paper is that one that she kept hammering on about how right to privacy is not an element of access to information rights. In the Nigerian context, freedom of information law. So the frameworks that exist for compliance and for accountability and compliance when it comes to human rights do not really exist, as much when it comes to right to privacy, So first of all, from the African context, in terms of what we've discussed as the legal framework that exists on the continent, and then even locally in Nigeria, I want you to speak to what your recommendation. I saw that you started a thought, and I want you to probably just finish it in terms of what would your recommendation be, speaking to how we can make sure that there are mechanisms in place, when it comes to accountability and compliance for what we already have locally in our constitution and whatever exists on the continent in terms of legal framework, especially since, we have that challenge that access to privacy and data protection is not yet seen as a human rights issue.
Is that a question for
No, it's for her.
Okay. Thank you. Well, like I was saying, I think involvement by all is important. Like I made the point that NIDA is, reviewing the data protection guidelines that it has for for the public sector, but now it's going to include private sector. That is you and I. And then NIDA would be approaching stakeholders, most of us, all of us here are stakeholders, for their input. So it will be time to be counted. Whatever views, that we have, how would we want these privacy issues to be, dealt with? We should have our input. Then I want to comment on the Freedom of Information Act. The Act actually, protects individual privacy. Under the exceptions, it talks about, for instance, lawyer-client relationship cannot be divulged. Medical records cannot be divulged. Then your private information cannot. So in addition, it protected states' rights to security, defense, when the information you want would affect adversely the relationship between Nigeria and another sovereign national. But it also protects the rights of the individual. So I just want to make that point that it was trying to strike a balance. So when we feel that right is being breached, I still maintain that it's our responsibility to pursue it. Let's make our laws robust, go to court. They say it will take too long, but you see, it will come to an end one day. I'll give an example, like I'm Igbo, and I know that in Eastern Nigeria, hitherto before now, women were not entitled to inheritance in their father's house, in their husband's house. So you begin to wonder, so where are they going to inherit anything from? Your father leaves nothing for you because you're going to marry a man, and then the man leaves the family, you don't get anything there as well. But it took one woman, Mrs. Modebe, in the 60s or 70s. She was widowed, and her husband's family literally threw her out of her husband's house, and she had 3 children. By the time the Supreme Court gave this ruling, this woman was like in her 80s. I'm talking like almost 30-something years after. But it established the locus that as a woman, you can inherit property in Igbo land. So I want to make the point that there's no pain, there's no gain. So, we have this laissez-faire attitude of, oh, for as long as my little corner is okay, what's my own business? But you see, your little corner might be okay, but one day that, I'm speaking now because I'm an Igbo woman, and then now I can say, if she didn't take the time to fight that battle, she was 80-something when the Supreme Court gave the decision, and she went to court like in the 60s. Thank you.
Thank you very much. That was a very good example, apt example. So I would come back to you, Professor Sibon, but Enrico, you started to talk about GDPR. And Dr. Shillon talked about the fact that most of the laws are derived from older standards, from Europe, 1995, EU directive, and now we're talking already about and these are the laws we have in place, and concerning some of these laws, we still have issues of compliance and all of that and enforcement, and now we're talking about GDPR, which is going to be in force from May 2018 and all of that, and 25th of May 2018. So it sounds to me like, is the continent coming on board 22 years ago? Like, what we're doing now, in terms of just having laws, for instance, in 54 minus 15, how many countries are those that do not even have a data protection law? Are we catching up 22 years ago? If we are catching up to 22 years ago, because even the AU Convention seems to be largely, and other laws that she talked about, if we are catching up 22 years ago, or if we are yet to catch up, and we're still talking and having these conversations about catching up 22 years ago, what are the implications for us to now run a race of 6 months, and catch up by May of 2018?
Okay, I think it's a very good question, and I believe also nobody has the answer, because so for what I'm seeing is that so there are, of course, many discussions, and there is lots of interest, especially from law firms, trying to make money, make all these big company compliant with this new regulation, which is important because it seems that it's going to affect all of them. But the reality is that, in the idea of the European regulator, this law is not going to affect only big players and big companies that can afford to employ, globally recognized international law firm that perfectly understand how to assess the data compliance, the governance, and the risk, right, of a company, but also, as I said, small and medium enterprises, and also the informal sector that might deal with European citizens, or with people that actually live in Europe, and it's evident actually that it is already happening. I had just a few days ago, a friend of mine has a small enterprise. She does translations. Most of her clients are European, and most probably because their prices are competitive with European companies that do translation. And what she was doing direct marketing with the companies that she found on the web, so publicly available email addresses. She was using these email addresses to send to send an introductory email. Hi, my name is, those are my services. Would you like to get to know each other better? Because I believe that would be beneficial for you. She received 2 warnings from a South African ISP on the fact that actually, according to this ISP, she was doing spamming. Yes, but the reality is actually that in South Africa, we have got, yes, an information regulator, but there's not yet an enforcement mechanism. So actually, she was not doing any infringement, infringing any kind of law, and neither from a European perspective, because actually the implementation of the regulation will happen only on the 25th of May 2018. But what is happening is that this ISP has been very recently, unfortunately, went through a terrible data breach, and it seems that, it's finding a way of being compliant with the GDPR. So, then there are issues of intermediary liability, so the ISP say, you know what, I'm sorry, but you can't deal with me anymore. She does not know at all what it is, the GDPR, what was wrong, why she can't send anymore an email to somebody to an email address that she just found online. She was not stealing this kind of information from anywhere, it was just publicly available, and she had to completely review her business and everything. So that requires cost of migrating to a new ISP, requires knowledge to read the regulation, try to understand what it is all about. It requires, to rethink about your strategy, how you're going to contact. It requires, am I going to get an advice of a lawyer, or so on and so forth. So if we really have a look at the African economy and, you know, what's the reality of the economy, so, you know, the small and medium enterprises, informal sector, and so on and so forth. And I'm really wondering, I mean, who will be able to be compliant by that deadline, and, you know, to really put in place a proper, you know, data governance, compliance, risk assessment.
Thank you. And a lot of questions raised there as well. Barbara, I'd like to ask you, what are your thoughts on gender issues that arise from these things we're talking about? Data protection, privacy. I work in the area of women's rights online as well. I completed a research in 2015 about how women access and use the web in Nigeria. One of the emerging issues is around tech-mediated violence, and also what is just possible in terms of creating safe spaces for women online to be able to express themselves, especially on sensitive issues and stuff like that. So speaking around these issues, what are your thoughts on the gender issues that arise? Because, you know, like somebody was talking about how, I think it was an informal conversation about how we always catch up later, you know, on very important issues. But, you know, it's important right now for us to begin to, you know, talk about mainstreaming women's rights into ICT frameworks. You know, so as we hold these discussions, I think that's also an important angle to look at.
All right. I'm not an expert in the topic, but I think it's something that is very important at the moment. Women should not be left behind, and gender-related issues for purposes of information technology and issues of privacy, and we need to be brought on board. And I think there's need for a lot of creation of awareness, because not only do these issues affect women, but they also affect men. And with a lack or inadequate awareness about the issues revolving around privacy and IT-related issues, I think it's incumbent on us as a network or a team to try and come up with some kind of mechanisms, first of all, and also agenda to try and incorporate women into this whole aspect.
Thank you, Barbara. Engineer Mena, as the head of cybersecurity with NCC, I wanted to ask, do you think that our legal framework in Nigeria right now, whatever we have, you know, that exists around data protection, is sufficient for trans-border flow of personal data? And this is related to the GDPR question. And, you know, first of all, if it is, in your opinion, if it isn't, what are the efforts of NCC to make sure that we catch up and we're where we need to be by the time we need to be there?
Well, first of all, it's not adequate simply because we need to have something focused on data protection as an issue. What we have right now, both the national legal framework, which include the National Policy on Cybersecurity, the National Strategy, and also the Cybercrime Act of 2015, are not really sufficient. There are aspects of data protection captured in the Cybercrime Act 2015, for instance, and it surely has not captured everything. And what we need to do is to work on a multi-stakeholder approach with data protection as it is. And also, like my colleague in NIDA mentioned, the Cybercrime Act, insufficient as it is, needs to be put into practice. But that is those aspects that concern data privacy need to be put into practice so that we can learn from the inadequacies there and also probably work on amendments to rectify such.
Great, thank you for your contribution, sir. And I'll come to Professor Seaborn as the last question. I'll probably ask, and I'll depend on my host to let me know if I have any more time to take comments and reactions from, and if I don't, I'll just get out of here as quickly as possible. And we can have the rest of the conversation over lunch. So the question I wanted to ask you is the question she asked in her presentation, and she just put the why. And I've been thinking about it as well. Why? A convention on cybersecurity and personal data 2014, up until now, only one state has ratified in Africa. That, that's funny. I think, and I'm as puzzled as she is, and I hope that you can provide some insight. Why?
I would probably use the word that the communications department that in the White House says. It's above my pay grade. But yeah, it's not actually funny. Well, I would state it, but I never said that to anybody. Just to cover the whole lot, one of the things which is important is that people don't know that they're already being surveyed, whether it's for local country or not. Okay? If it's live, then my boss is going to kill me for that. It's not funny enough because it's actually been identified for, I was last week at a NATO meeting. We were talking about intelligence community, and some of the things that came out of there is that some part of Africa is identified as potential partners, and some part of it is not actually identified as potential partners. And that depends on how EU decides and how the NATO wants things to work. Now, Africa is full of resources, and EU still has intentions in there, but NATO has different intention. I don't know whether people have actually seen it, but I would actually urge all of you to actually go to the NATO website now, because you will see that NATO has now an African perspective, which was never there before, which has just started. So give your mind some quick picks why it is happening. I'm not going to give you the direct answer. I'm just giving you the questions so you can actually mind it yourself. It's based on how much information we have on the other side, who they want to protect, who they want to get rid of, which answers a bit of the questions with, it's not puzzling to other people on the other side. It's puzzling for Africa, yes. Because when they look at all what is happening, you would see some countries actually going very fast on certain things. For example, I was talking about Mauritius. We're fast tracking GDPR. It's going to go in like in January. We're going to overhaul everything fast track. Because a lot of BPOs from EU have their operations in Mauritius. Now, there are a lot of other countries in Africa who've got operations. But the question to ask is, as you said, the puzzling part is what's happening. Is it the country itself, or is it somebody else who's actually deciding on the other side of the wall saying, do we want to do business with them? And that question you should actually ask the Germans. Unfortunately, yeah, because they have their different views and different perspectives. And that also implicates my big boss, who actually thinks we should not. Don't forget that one of the things that he actually promised to people was that he would only do business with countries who are interested to do business one-to-one with him. So that should actually give you the indirect answers, the puzzling parts. That's what's happening right now. I hope he's not watching.
All right, thank you, Professor Stibon. This has been a very interesting panel for me. I've heard a lot of things, but I think that I'll summarize them in what I've heard is more advocacy, more awareness, broader consultation, more technical support to local actors and businesses and maybe potentially all stakeholders in this conversation. So I think we'll take the rest of it to lunch. I'm not sure we have any more time. Thank you all, ladies and gentlemen. Thank you, everyone.
Okay, can we clap? Can we put our hands for them again, please? So we can definitely continue to interact more during the breakout sessions, which will be after lunch. So that will be quite interesting. We'll be dividing into 2 groups after lunch. But it's time for lunch, and I would like to just gently remind us that there will be a gala night at 7 p.m. today. So we're all cordially invited for that. So, Rest Code, come ready to boogie, have fun, and also learn. It's a platform for networking and relationship building, so you can come comfortable. Okay, so because we're a bit short for time, lunch is for 30 minutes. So the earlier we get there, the earlier we come back so we can round up this session. Okay. So we have our members of our ushering team standing right out the exit, so they will be issuing tickets just to get the orderly progression for lunch. Okay, thank you.